Anyway, welcome everyone to the Office of Gift Planning's annual estate planning webinar. It's a service that we offer to all friends and alumni of Stony Brook University. For those of you who've worked with us, you'll recall that we're the office that helps people in general think about different ways to establish a legacy, give more creatively, smartly, or even tax advantaged within the Stony Brook universe. And Stony Brook has so many truly exceptional areas to support these days. Of course, everyone knows the university. They know the Stony Brook Medical Center. They know Stony Brook School of Medicine. But we also have people here from the Stoller Center or Friends of the Stoller Center, people from the Osher Lifelong Learning Institute, supported from the New York Climate Exchange, supporters from athletics, which I just read the girls lacrosse team won their conference championship, so congrats to them. We have alumni, faculty, grateful patients, as I said, friends, members of the community in general. So we welcome all of you. We're happy to do this. We're so pleased that Mark here is willing to do this for us this year. Know Mark for, I guess, about a year now. I've been at Stony Brook almost 2, so it's been great getting to know him. He's a fantastic speaker. He's a fantastic person. I asked for a bio, and I think I got one of the biggest undersells in history with 2 lines that he sent me. So I will say that, in addition to what I'm going to read, he's also on our Stony Brook Children's Hospital Advisory Council. I know he's big in the philanthropic community, and we really appreciate him being here tonight. So without further ado, Mark Essagarari is an attorney in private practice in Smithtown, New York. He has been in practice since 1988 and provides extensive estate and tax planning services to individuals and businesses. And without further ado, I give you Mark.
Thank you, Sean. Thank you. I'd like to start by just talking a little bit about estate planning, and then I'm going to pause and take some questions, and then we'll continue on with the conversation. So, the biggest obstacle to estate planning is simply procrastination. It's the putting off of doing what is necessary to plan the estate. So I wanted to say a very big congratulations to all of you, because on this beautiful sunny evening, you're here. So that's great. That's really good. Really mean it. Congratulations. And thank you, Sean, for the opportunity to speak to everyone that has joined the call. When we talk about estate planning, sometimes people think that, I don't have an estate. I'm just a regular person. But actually, everyone does have an estate. An estate is simply all the things you own. For many of us, it's your home that is your largest asset. Could be the retirement account. If you're at Stony Brook, you might have a retirement account that can be substantial. There can be other investments, cash. And then there is even, I like to make sure we talk about the non-financial assets, the kinds of things that have high sentimental value that without some good planning, unfortunately, can really tear the family apart, because sometimes people will argue over something that there's only one of, like mom's engagement ring. So thinking through both the financial and the non-financial can be really important. Now, as we were just getting started, a person said, I find this very frustrating. I find this, kind of a source of confusion and frustration. And I wanted to say, I hope that through the talk today and through you participating by asking questions, that we can make this really simple and easy and clear. That's always my goal when I have a chance to do any kind of education and talk with folks. So let me just start with some of the basics, which is, what's the difference between a will, a last will and testament, and a trust? And really simply, a will only goes into effect when you die, right? A will goes into effect when you die, and it has your instructions about what should happen with the financial assets that you have when you die. However, in today's world, we need to do some planning around what happens if you don't die. What happens if, unfortunately, you became incapacitated? You were still alive, but not able to make your own financial decisions. That's really important because that's happening as folks are getting older, and a will simply doesn't cover that situation. Another difference between a will and a trust is that when a will is prepared, our traditional last will and testament, like I mentioned, all wills must be probated when the client dies, meaning the will is not valid until it is brought to the probate court, where it is then probated, and the word probate meaning to prove or validate. So that's a big difference, because when we talk about trust planning, the trust planning that you do is in fact fully effective and valid the day that you sign it. You sign it and that trust becomes effective. It becomes effective right now while you're alive and does not require a court to be involved when someone dies. Here in Suffolk County, we have one probate court. They're located out in Riverhead, and that one probate court has only one probate judge. Now, they have staff and they work hard, but you can imagine that filing for a probate to have the will reviewed and proven or validated is something that can take some time. We saw, for instance, during the pandemic, so many people pass away. Like many places, the probate court was shut down for some period of time. It meant families that were relying on a will to be able to effectuate the transfer of assets at the death of their family member were on a complete hold. And then when the court did reopen, we had a significant backlog of cases due to the amount of people that passed away. So I talk with each person about their own situation, but I wanted to kind of introduce the subject of estate planning with the idea that for many of the people I work with, trust planning will be something that they will choose as an option so as to avoid the need of probate, which can cause some time delay and stress for the family. Let me pause here for a moment and just see if there are any questions about the use of wills, probates. And please, I encourage people to ask any question that's on their mind, because if it's on your mind, it's probably on the mind of a couple of other people, and you're just the one that's courageous enough to ask. So I can't see you, unfortunately, but Sean can, and so...
So we do have a question from Johnny May, who asks about what's involved with putting your house in trust and the thought behind that.
Sure, perfect question. So let's talk about trust in general first, okay? The idea of trust planning is that only the assets in the trust, so Johnny, you're correct, only assets that are transferred into the trust are now controlled by the trust. So if someone creates a trust, but the lawyer or the person they're working with doesn't assist them to get the asset, the house in this case, into the trust, it simply doesn't work, because a trust only has control over assets that are transferred into the trust. So, Johnny, I'm going to assume that you own a home and that right now your home is in just your name. The human being, Johnny, owns that house. And is your name Johnny May? Was it a chat?
It was a chat thing. Johnny May Alston. Yep.
Okay, so Johnny May, I think, is your first name. So Johnny May, the house that you own may well be titled to your name, the human being Johnny May. Now let's just talk about some of the downsides to that. You're a human being, which means you could get sick and you could die. So right now, while you're alive and well, if you wanted to sell your home, mortgage your home, your signature, you would sign, and that's what would effectuate the change. But what if you got ill? What if you were too ill to sign or you died? That's when we have to go off to the probate court to have the judge then be involved in signing on your behalf. Trust planning allows us to do the following. We create the Johnnie Mae Trust, and now we transfer the ownership of the house into the Johnnie Mae Trust. And the beauty of that is the Johnnie Mae Trust is not human. It never gets sick. It never dies. And we always have someone who's authorized to sign without having to go to the court. I believe your question was centering on what exactly is involved in transferring my home into the trust. And as an attorney, I would prepare a deed for you that would simply say, Johnnie Mae transfers the home into Johnnie Mae's trust. And you would sign that. Here in Suffolk County, there's a fee to record the deed with the county clerk, and we want to do that. And that fee is approximately $450. Depends on how many pages the deed is and whatnot. But that's something that certainly can be done.
Mark, Violet wants to know also, can you have both a will and a trust?
Yes, Violet, absolutely. In fact, I would say that 100% of my clients have both a will and a trust. Now, we want to rely primarily on the trust. So we want to make sure that all the important assets like the house, the investment accounts, those important financial assets are in the trust. But it's good practice to also have a will. When I say good practice, I mean it's a proper procedure to also have a will, because there can be something that's left outside of the trust, maybe an error. And when someone dies, we need a backup plan. We call that a pour over will, a will in which we have to go to probate court, so that's not ideal, but we can transfer the assets from the person into the trust.
Great.
Okay. Mark, we have someone who has their hand raised, Fran. Fran, if you'd like to ask Mark a question. You should be asked to unmute right now.
You guys are doing great with the participation. Thank you.
We're trying.
I raised my hand.
Yelena, just give Fran just 1 second and I'll come right back to you. I think Fran did unmute.
Yeah.
So in the trust, though, I've heard that sometimes like you couldn't sell the house. I guess it depends on the type of trust, that if you sell it, the proceeds go back into the trust. So like, is there a different types of trust?
Perfect question. Perfect question. Yolanda, I won't forget you. I'll be back in just a moment. Okay. So yes, there are two really primary types of trust. There is what's referred to as a revocable, with an R, revocable living trust. Sometimes we shorten that to just living trust. And that's a type of trust where we get really great protection against probate. We can talk some more about it, protection against taxes. But we do not get protection against the cost of care. Now, for many of you, I think you know that, while you're working, you have health insurance often from your employer. When you get to be 65 years old, you qualify for a government insurance program known as Medicare. And Medicare, in order for you to qualify, really just asks you one question. And that question is, how old are you? And if you can say I'm 65 or older, then Medicare covers the cost of your care at hospitals and doctors. So Medicare will cover the cost to fix you, to make you better. Now, what I'm giving to you is just a simplification so that you have a good understanding. But here's the problem. The problem is that what if they can't fix you? What if it's not a broken bone? It's not a surgery that you need. What you need is actually just help with what we call activities of daily living. You just need some help at home with getting out of bed, using the bathroom, eating, things like that. That's where Medicare will say, no, we don't cover that. Okay. And Medicaid is the government insurance program that has a really bad reputation. They need to get a PR firm because nobody seems to like Medicaid. But Medicaid will pay for assistance with daily living, pays for nursing homes and pays for home care. That's when we're working with older clients that are, for instance, 75 and above. We're going to talk to them about a Medicaid protection trust. And that's what I think you were talking about. The Medicaid protection trust is where you can definitely sell the home, but we want to keep the value of the home in the trust, because if we return that value back to the client, that money would be subject to or available for Medicaid or nursing home. The cost of care could take that money. Did that help answer the question? I'm not sure if she's still there or we lost her.
I think we lost her. But
Okay.
along that line, someone asked a question in the chat: if you change alter the condition of an irrevocable trust, how does it affect the 5-year look-back period for skilled nursing facilities and other benefits?
And Yolanda, I haven't forgotten you. I'm making my way back. So were they asking about a revocable trust, Sean?
It says irrevocable.
Irrevocable, right, correct. Okay, good. So in the world of irrevocable trust, when doing this type of planning, okay, the first thing I think is so important to know is that almost everyone I speak to does not want to go to a nursing home. If given the choice between receiving care in their own home or care in a nursing home, they would prefer to have the care in their own home. Now, under the current law, I want to remind everyone, there's no 5-year waiting period. Okay, so this is a big, big benefit. If you know someone who's unfortunately struggling to be at home, whether it's dementia, their mind is not working well, or their legs are not working well, but something's causing them to struggle with being independent at home, home care is a real option. And home care does not require any 5-year wait. In fact, the waiting period for home care is just 1 month. So if somebody came to the office and we created a trust and put their assets into that trust, they can qualify for home care in a short period of time.
Mark, while you're talking about trusts, someone did have a question about the costs and how they compare to going through probate.
Yes. Before I do that, I just want to get back to my friend Yolanda and see what she was up to. She's been very patient, and then we'll come back to the cost of care.
Yolanda, you should be able to unmute.
All right. Yeah, thank you. I actually have a ton of questions, but when you mentioned Medicare and Medicaid, Medicaid, if we worked and have some assets, we won't qualify for Medicaid. And if we go to a home, God forbid, then they will take our assets. Who will pay for that home? It's very expensive.
Yes. So let me address that with you. You ask a perfect question. Okay.
I actually have another one that I had before. You mentioned that Medicare, Medicaid. So get back to me at some point, please.
Absolutely, I will. But let me do your first question here. Okay. You're right. The cost of care, nursing home here on Long Island right now is a minimum of $15,000 a month, $180,000 a year, and in some cases can be even more than that. And when I say a minimum, I mean in general.
Mm-hmm.
Okay, in general. Now, remember I said to you that Medicare is a government insurance program that asks just one question, and that one question is, how old are you? and you get hospitals and doctors paid for under that insurance program. Medicaid, as you were mentioning, Medicaid asks a completely different question. And that question is, are you rich or are you poor? Okay. And they identify or qualify you as rich if you have more than $30,000. Okay. So basically everybody's rich to them. So what do we do about that? What do we do about that? Well, I'm going to give you a really simple example. This is extremely simple, but pretend that a client comes to see me and they have a bank account, and that bank account has $22,000 in it. Okay, and it's in their name. And then they have a home, and that home is worth $1 million, fully paid for. So they have $1,022,000. Okay. Now, they will not be able to answer the question, I'm poor, because they own $1 million home plus a $22,000 bank account. But if we take that home and transfer the ownership into a type of irrevocable trust, what we call a Medicaid protection trust, they still live in the house. Their real estate tax stays exactly the same. Everything in their life is really the same. But now, if asked the question, are you rich or are you poor? They can say, I remember Mark told me, say poor. I'm poor. I only have in my name this $22,000 bank account. And therefore, we've fully protected the house. So Medicaid will pay for that care, but we have to do the planning up front. Now, I'm not suggesting at all that everything goes into this type of trust other than $22,000, because that's not going to work. But for many of you, you've got some assets that are a perfect fit to go into this type of trust, like your home. Okay. You may even have some investments, some life insurance. There will be some assets that you want to keep out of the trust and some assets that you want to put into the trust. And the assets you put into the trust we call protected, and the assets that you choose to leave out of the trust unprotected. For a lot of the clients that I work with, they're a little surprised, but when they take the time to think about their home, their investments, their IRA or 403b, their life insurance, their bank accounts, it often will total up to $1 million or more. And so what we're doing is protecting against a catastrophe. If we can get $700,000 into the trust, we can protect against getting wiped out due to the cost of care. So I hope that helps. Any other questions from anyone else in the area of the trust planning itself?
There was someone with a question just about the costs associated with establishing a trust versus probate.
Thank you. Thank you.
Sure.
So the trust planning, the versus the cost of probate, you know, it's like very often how many things work. It's a pay now, pay later kind of scenario. Paying now being less expensive than paying later. If a person is looking at what are the costs of, for instance, having a will is going to be less expensive to prepare. I'm going to say to have a will, and we're going to talk about healthcare proxies and related healthcare documents, powers of attorney. That kind of package of documents comes with a cost of about $1,500, $1,500. When we're talking about trust planning, we're talking about a much higher cost, much bigger piece of legal work, and the cost there being somewhere between $9,000 to $12,000, so substantially more. Why would someone choose to do that? Because when they have the trust planning, they can protect against what we were just talking about, the cost of care. You know, a will can cost a person their home. If they unfortunately get ill, they can lose their home. That can be a $500,000 cost. In particular, when coming coming up with the subject of probate, I believe the last time that it was studied, the national average was about 2.5% of the size of the estate. So if someone had $1 million estate, their probate cost would be about $25,000. And when someone has a trust, depending on the nature of the trust and the size of the assets, the cost is going to be less. I'm going to say something in the neighborhood of $7,000 or $8,000 when they pass away. And there was the original, I'll say $8,000 to $10,000 to set it up. But the protection and the difference in the protection can be dramatically different. Does that help to answer the cost question?
It does. And we have one other question. Should married couples have a separate trust for each spouse?
So the design of the trust is something that's really specific to you. For many married couples, they will prefer to have one trust, one joint trust. We can simplify their life by doing that. But some of you may be physicians. Some of you may have some type of malpractice liability issue. You may have professions. There may be a variety of reasons. It may be a second marriage, and each of you came to the marriage with different assets and different children from your first relationship. So it's never one size fits all. Estate planning is truly unique and intensely personal to each family.
Along those lines, Mark, there's sort of a joint question of what sorts of things should you leave outside of a trust? And also, is it advisable to put something like a 403b, 401k, or other retirement plans in trust?
Okay, another really important question. For many of you, your home and those retirement accounts are some of your largest assets, okay? The retirement accounts, the 403b, the 401k, the IRA, those are not a good fit for these trusts, okay? The transfer of those assets into the trust while you're alive, whether it be the living trust or the Medicaid protection trust, would create an immediate need to pay all the tax on that money. So you do not want to do that, okay? Now, that doesn't mean we can't protect those assets. So that brings us to the power of attorney. Power of attorney is a legal document where you can appoint someone to make financial decisions. And it is the power of attorney that is what will help us to guide and protect these assets if you became ill. And when I say these assets, I mean 401ks, 403bs, IRAs. So it is a bit of an intricate puzzle, and I don't want it to be complex. I want to say to you that through the proper estate plan, often clients will choose to have both a trust, whether it be a living trust or a Medicaid protection trust, depending on what phase of life they're in. If they're in their 30s, 40s, and even 50s, typically a living trust is their choice. If they are in their 60s, 70s, 80s, then the Medicaid protection trust. The use of a will, we always want to have a will just to be able to kind of clean up anything that got left outside of the trust. And then the power of attorney is the legal document that helps us to control and protect those really important IRA, 401k, and 403b plans that many of you have a good portion of your wealth in.
Great. We have a number of people with their hands up. So if you don't mind, Anne Reinhardt, if you could unmute.
Hi. I just wanted to ask you, what if you don't probate? I mean, like, both of my parents originally resided in Florida, and my mom died first. My dad died after her, and I was his power of attorney. But they had nothing. So, I mean, they had wills, but there was no assets, you know, anything within material things. There were no issues amongst the family members. So I never did anything
And
about it.
that's okay, Ann. That's totally fine, because when there are no assets, then there is nothing for the probate court. The probate court's really focused on assets. Pretend for a moment that your mom and dad had a bank account, okay? And that bank account was owned by both of them, okay, both mom and dad. And then when dad died, that account would just automatically go to mom because of joint ownership. You would have come into a problem if your name wasn't on that account when the second parent died, because then we would have had an account that no one was authorized to sign on. So when you say they had nothing, I think there was probably a little something they had, but they had already added your name to the account. Does that sound familiar?
Yeah, I was on the account with my dad at the end through the power of attorney.
Right. Okay. And so that is what helped to solve the problem of probate. And you know, when someone has very simple or minimal assets, we don't need to do this big kind of trust planning. You know, we can, if someone comes to see me and they have very simple kind of circumstance, sometimes we can create a plan without that. I mean, it doesn't really make any sense, right? If the assets that the person has total up to $20,000, then a legal fee of $8,000 to $10,000 just makes no sense at all.
Right.
But for many of the clients that I work with, they own a home. Sometimes they have two homes. They have, you know, pretty substantial assets. And when I say pretty substantial, I mean something heading toward $1 million. That's something that some really good planning is necessary. I'm always happy to hear that things worked out and there wasn't any kind of fighting or problem, but too many people know someone whose parents passed away, and now the brother doesn't talk to the sister, the grandchildren, you know, the cousins don't talk to each other. I feel like one of the most important things that I can do is help to maintain family unity, to see that the parents or grandparents' instructions were followed and carried out, and that something that's a good thing, the gift of some wealth, doesn't end up dividing the family or destroying the family. Let me just also add something else, that for some folks who have a sense of wanting to give back not only to the family, they will have what we call, you know, donative intent. They want to favor a charity or an institution that they think is doing good work. And we can always include those kinds of instructions. And again, for some families where things have gone really well, their business has done well, they've had a great career, the tax law can be our friend when we have you know, this donative intent, some opportunity to share the wealth, so to speak, for the greater good. That may not resonate with all of you, but it for those that are considering that can be an important part of any plan that we do. And did that help to answer your question?
Yes, it did. And I just wanted to mention to you, I worked for many years with your dad.
Oh, great, great.
And I loved your dad. Yeah, he was a
Thanks.
great guy.
He is 93 years old, living in
No.
Naples, Florida. He is 100% on top of his game. His favorite pastime is to go anywhere where they ask for his identification. because if he's going through like the airport at TSA, they stop the whole line and say, "Can you believe it? This guy is 93. He's doing great." And thanks. I'll let him
know. Yeah, let
Okay.
him know I said hello.
And may I just ask you one more question? Where was it? Were you like what hospital and what floor were you on?
Yeah, St. John's for many years.
Okay.
And, you know, I was also one of his patients at one point. So I worked throughout the building there for many years.
Okay, because he usually remembers you by like Ann from 3 North. You know,
Yes,
he knows.
3 North.
knows-
I was on 3 North and 2 South.
Okay, very good. 3 North and 2 South. He'll know Ann from there. Thank you, Ann. Thank you.
Okay.
You know, which brings me actually, this is perfect. This is perfect. Brings me to the next subject, which is the healthcare documents. You know, my father was a surgeon. He took care of a lot of people in this area. And I'm really proud to be his son. I really am. But, you know, my dad would always tell his patients, "You're going to be okay. You know, you're going to be okay. You're going to be fine." I'm here to tell you you're not. And that 100% of you eventually are going to die. You know, that's just the facts. Okay. And we have to do some planning here because, you know, we spend more time planning a beautiful vacation than we do planning what is the inevitable end of life. You know, at least the physical end of life. So I want to talk a little bit about the healthcare proxy, the living will, and something called a HIPAA authorization. Now, those of you that are in, you know, the medical profession, you may be familiar with some of these things, but let me just review them for everyone's benefit. If there comes a time that you're not able to make your own healthcare decisions, you know, as long as you can make your own healthcare decisions, your physician, your healthcare providers are going to ask you. But if there ever came a time that you could not make your own healthcare decisions, then the healthcare proxy is where you are appointing a person, a proxy, an individual, often a spouse, a son or a daughter, to be able to make medical decisions for you. Should I have a surgery? Should I not have a surgery? You know, those kinds of questions. Now, the healthcare proxy requires that you choose one person at a time. And the reason why is we can't have a committee. Can't have a committee on what to do. There needs to be a chain of command. You know, my spouse makes that decision. If my spouse can't, then my oldest son. If my oldest son can't, then my daughter. You know, whatever the order may be that you choose. The living will is the one where it's almost like you're giving them your marching orders. You're saying, listen, if ever it occurs that I can't make my own decisions, then I have some instructions that I want you to know about. In particular, if there comes a time when there's no reasonable expectation for recovery, you know, there's not no hope. As long as there's faith, there's hope, but there's no reasonable expectation of recovery, then many people, and this is again intensely personal, many people will say, you know, I do not want to continue with the heart machine. I do not want to continue with the lung machine or tube feeding or even antibiotics. Now, this is totally up to you and something that you'll talk with your lawyer as you prepare these documents. But it's real important because it can tear the family apart if they don't have your instructions. If some of the family thinks that you wanted to stay on advanced life support and some thinks it's cruel and that's not what you wanted, this is not something people can meet in the middle on. This is one of those things, having your instruction down in writing, I have witnessed countless times, has brought clarity to a very difficult situation and kept the family members from you know, fighting about what they think is the right answer. The last document that we need to include in the proper estate plan is the HIPAA authorization. And HIPAA is a acronym. It stands for Health. The I is Insurance, Portability, Accountability Act. It's the government. They make these things up. Okay. I just want to tell you that's what it is. Now, why do we have this, and what is HIPAA all about? HIPAA is all about protecting your private medical information. This is something that was originally passed by the Congress in 1996. Okay, so it's been around for a while. For a little while, nobody even knew it existed. So, you know, if you were in a hospital setting in 1997, there's some chance that nobody even knew about it. But now, today, everybody knows about this. And the design of it was that insurance companies were starting to keep databases of people's health. And they were starting to exclude, saying, oh, you know what? You don't want to insure Al over here. He's got all these problems. So the government said, no sharing of private medical information without the patient's consent. But it kind of got a bad side effect, which is it meant that medical providers are not authorized to even share information with a spouse or a son or a daughter. And this becomes a real hardship. And I want this to be real for you. You know, for those of you that have been to the doctor, you've noticed that, you know, when you get there, the doctor requires that you fill out a form or they can't talk to your family members. So here, I just want you to know, like, this is critically important, because if you end up at a hospital that your doctor is not affiliated with or doesn't have privileges, you get all new doctors who don't know that it's okay to talk to your family. And if you're not well enough to sign these documents, they are under an obligation not to share information with your family, and that can be super uncomfortable. So let me see if there's any other questions on any subjects.
We have a whole slew of questions, so ask and you shall receive, Mark.
Okay,
I'm
great.
going to try and combine a few of them together. So beneficiary designations, can you just confirm it's easier to simply name beneficiaries on retirement plans rather than do any advanced planning? And then sort of to take that one step further, what about payable on death or TOD accounts, and how are those affected?
Yes, perfect. Right. So, you know, easier is not always better. Okay, but yeah, sure, it's easy to name a beneficiary. Say you've got, I'm just going to choose a $500,000 retirement account, and you want to leave that account to your son. Okay. And so you name your son as the beneficiary. That's easy. Okay. An issue in today's world is, what if after your death, when the son inherited that IRA, what if unfortunately his marriage fell apart? You know, we have to really deal with, when they talk about a 50% divorce rate, all of us have been touched by that. Okay? You know someone who has been divorced. And one of the things that I think our trust planning, I know that our trust planning does, that clients want to make sure is in place, is a bloodline protection. Meaning, if you leave that asset to your son, that asset stays with your son, even in the case of an unfortunate divorce. Okay, so naming a trust as beneficiary is certainly a complication, but it can make the difference between him keeping that or losing that in any type of lawsuit. Unfortunately, the most common lawsuit that people lose assets in is a divorce. Now, the same kind of situation with the payable on death account. Payable on death is, again, where you name a beneficiary. We're talking about a modest account. It's great, no problem. But when we're dealing with more complex assets or larger assets, we can run into the same kinds of problems with divorce protection or lack thereof. we can end up with, in both situations, if you're trying to provide for younger people, and when I say younger people, I don't mean just people that are under the age of 18, but even grandchildren who may be, 23 years old. In my mind, I think there's a maturity inflation. Many of our older clients went to war at 18 and took on tremendous responsibility. Many of the youth of today, even at the age of 25, would certainly struggle to change a tire on a car, and likely not so good at taking care of things. So, when it comes to financial assets. So I think all of that's important.
Great. We're circling back to some trust questions here. So
Okay.
what benefits other than avoiding probate does a revocable trust provide?
Some of the benefits we were just talking about, in addition to avoiding probate, would be this idea of a bloodline or divorce protection. Currently, when we talk about estate tax, and I didn't touch on that because for many families, estate tax is not as big an issue as it used to be. This is a political question. There are times when the amount let me just start again by saying estate tax is a tax that is charged when someone dies. Okay. Now, thankfully, under the current law here in New York, that tax does not apply unless the estate is close to $7 million. So, it's become less of an issue. All right. However, not to be political, there are people out there that want to change those numbers and reduce those numbers to somewhere between $1 to $3 million. And so this is something we have to kind of monitor and be on top of, because there are times when estate tax is a major issue. If you have more than the amount that passes tax-free, historically, that tax can be between 45 and 55%. Okay? But I would say, in summary, the trust planning allows us to really maintain family unity, to be able to ensure your instructions are followed, protect against any kind of lawsuit, divorce unfortunately being the most common, as well as in certain circumstances, there can be some real protection from tax.
Great. So the mechanics of a trust. So who administers the trust? How do you access funds that are in a trust, or do you lose access to them entirely? How are they managed in that way?
We certainly know that clients, what's most important to clients is that they maintain control. So even with the use of irrevocable trust, we want to make sure that you are the boss and that you continue to maintain control. Now, the access to assets, let's just start with the revocable trust. That's where most commonly you will be the trustee and you will access assets in exactly the same way. If it's a bank account, you'll sign the check. If it's a real estate, if it's a home, you'll sign the deed. Nothing really changes there. In order to get that higher level of protection against the cost of care, on the Medicaid protection or irrevocable trust, we need to include someone other than the client as the trustee. And that will often be a trusted son or daughter. And that means in order to access those funds, we need to work with that person, the son or daughter, to sign off. Now, a question that comes up, what if my son or daughter, my trustee, refuses? Well, in the trust that I prepare, we always include the provision that you can fire that trustee and choose an alternate person. So if the son or daughter isn't doing what you need them to do, you're not out of control. You can say, hey, son, if you don't transfer the assets I'm asking for, we're going to need to remove you as trustee. These are all really good questions, and they point up sort of the need to get with your attorney and talk over the details of your own situation. I think that's critically important.
sort of along the lines you're talking about trustees, but this can also apply to executors, is oftentimes you either outlive your family or your friends or people that you trust. So what happens if you don't have any relatives who you trust to be a trustee or an executor? What would you do in that case?
Yeah, sometimes someone will come to see me and, you know, they don't have children or they don't have someone that's a generation younger, and it can be a real challenge. There are professional trustees that, you know, the family can interview to see if that's a good fit. There can be, again, in that situation, the fit for charitable giving can make sense as well, and the professional trustee can be the one to facilitate the transfer of assets to the charity. But it points up exactly what we were just talking about, this idea of really, you know, spending the time to protect, you know, or think through how you want your life's work to be handled.
Great. One sort of mechanical question again is, do you have to own the property outright? For instance, can you put your portion of a home that you own with, say, 4 siblings into a trust?
Yes, yes. So that is absolutely possible. If you are a partial owner of a piece of real estate, you can transfer your portion into the trust and protect those assets. You may be a partial owner of a small business. You may be the partial owner of a number of assets. Anything that you have is available for transfer into the trust, so long as you do have ownership in it.
Great, great. So I know we've got a few folks that have been waiting. We have more typed questions, but we'll get to some folks that have been waiting for a while. So Beryl Huerman, if you'd like to ask a question, here you go.
I think you need to unmute, Beryl. There you
Hi,
go. Hi.
can you hear me now?
I can.
Okay, so the question really is just the pros and cons of revocable versus irrevocable trust. And maybe that was answered in your statement about the ages, but I'm just not sure if there's other reasons to consider one versus the other.
So thanks for the question. The pros and cons are, and let me start by saying, you know, when I think about my own situation, in my heart of hearts, I really believe right here that I'll never get sick. That's what my heart tells me. But that's kind of foolish, because my head knows that I have no idea what my health will be in the future. And I know that some portion of people, some percentage, there are all different studies, some as low as 33%, some as high as 50%, that will need some type of care during their lifetime before their death. So that informs this decision about the pros and cons of the living trust versus the Medicaid protection trust. If I choose the living trust, the pro is no one else is involved in my business at all. I'm the only one who signs. There's no need for me to coordinate or discuss any details with a son or daughter or any trusted family member. The con of that is that if, unfortunately, I do fall sick and need care, that care really can cost several $100,000s a year. And if I need that care for even 5 years before I pass away, I could lose $1 million. So this idea of losing control, we have to include in there the possibility of losing $1 million to the cost of care as a form of losing control. And this is a real life. What you're pointing to, Beryl, is something that I talk with clients about when they come in and I interview them, and we talk about their family, we talk about the assets they own, and then we do the work of discussing what are the pros and cons of the two different kinds of trust planning and what really works in their family. And often clients will keep a good portion of their wealth out of that type of trust so that they can continue to feel independent and in control during their lifetime, but also a good portion in the protection trust so that they are feeling comfortable that they're not going to lose their life's work because unfortunately they got dementia or something else happened that they weren't able to function the way they thought they could. Does that help, Beryl? Oops, you're on mute again.
Thank you.
You're welcome. You're welcome.
Perfect. So there's a question that's been here for a while, and it's sort of ancillary, but it's also an important thing that many people deal with is, do you have any suggestions for parents planning for special needs children in the future?
Yes, yes. So that's also really important planning, because when someone has a special needs child or grandchild, this is a person who, if they were to receive assets, if they were to receive, again, even just a few $1,000s of assets, they can lose their government benefits, okay? We talked about Medicaid and the fact that Medicaid doesn't ask how old you are. They ask, you know, do you have money? Are you rich? Are you poor? So special needs planning allows a parent or grandparent or any family member to leave us any amount of assets to someone who may need financial support, who's getting financial support from the government, often Medicaid, and doesn't want to lose that support. And we can build that right into any type of trust planning we do. And that's certainly really important. And then choosing a trustee who's going to manage those assets for the special needs person is, again, a important conversation that needs to be had with your attorney.
Great. Robert Stafford's been waiting a while, so we'll if you can unmute and ask your question.
Rob, you're still on
Yes,
mute.
hi. Can you hear me now?
We can.
Yes, I have a question on the Medicaid irrevocable trust. Suppose I have a house and I've fallen ill and I need assistance. Can that Medicaid irrevocable trust be set up immediately and protect my house assets, and I still be able to get aid at home that I need?
So the answer to that question is yes. In that, remember I said that home care does not require that 5-year wait. So that if you fell down and needed care, that you broke your hip or whatever, and you needed care, you're going to get some care at first at the hospital, and you're going to get some care through the Medicare program. But once you go past, and I'm approximating here, 100 days, that's where Medicare is going to stop. And if we put together this Medicaid protection trust, you can get care at home without any delay. But I want to caution you about taking this kind of wait and see attitude, because sometimes we don't get to choose. Sometimes the home care is just not available. If you go to any nursing home, you'll see that it's filled with people. And if you were to interview any one of them, I would venture to say that none of them would say, I want to be here. My plan was to get to this nursing home. Said no one ever. And so I don't, I work really hard to do whatever we can to keep our clients out of nursing homes and get the care they need at home. but sometimes it's just not possible. And if you take this wait and see attitude, you can run into a pretty significant problem because now you've got a 5-year wait. And I'm dealing with that right now with a client that I worked with in 2003, 21 years ago, who we chose the revocable trust, which was the right answer for them. But then 21 years later, unfortunately, fell ill, and the type of illness requires, and the family situation requires that she be in a nursing home. And now we've got a significant problem. She's going to have to pay for this 5-year period. So not ideal situation. We want to be more proactive, I would suggest, Rob, if that's okay.
Okay.
Thank you
Right.
for the question. Thank you very much for the question.
It's been asked a couple of times. Does New York have a Medicaid estate recovery provision, or is?
Yes, yes. So that is also, let's just talk about working with an attorney and working with a non-attorney. There's some problems with the, I'll say results in that getting Medicaid and getting Medicaid to pay for care, that's important. But also getting that done in a way that New York cannot recover what they laid out. That's the estate recovery aspect. We need to really be thinking that through. And sometimes people have a kind of false victory in that they get mom or dad on Medicaid, but when they die, the state comes in and says, oh, well, we laid out $1 million. The first $1 million comes back to us. And that can mean that people lose the entire house and a majority of the assets for sure.
Great. So in New York, if you have people designated as beneficiaries, but you have not chosen a person as power of attorney and subsequently become incapacitated, can someone go to surrogate's court and get power of attorney or guardianship and change those beneficiary designations on the accounts?
Oh, that was a mouthful of a question.
Yeah.
All right, so let's just slow that down for a second. Let's go back to just talking about the power of attorney. Who you give power of attorney to is a really important decision and needs to be done carefully, because what you're creating essentially when you give someone power of attorney is like a carbon copy of you. If they have a full power of attorney, they have authority to do all the things that you could do. They could change the beneficiaries. They could do, anything that you could do. Now, if you do not have a power of attorney and you go to, and your family is faced with going to the court system in what I sometimes refer to as a living probate, death probate when the person dies, probating the will, living probate, meaning they can't sign, and we need the court now to step in and select someone to be like their power of attorney. The court is going to, be pretty careful about the authority that they give. And I would find it unlikely that a guardian would have the authority to change beneficiaries. Now, if you fail to name beneficiaries, then the law provides for something called intestacy. Sounds a little bit like a dirty word, right? But what it means is, at 7 o'clock, we have to be a little salacious, right? So what it means is that the law provides for who gets your assets. And for some people, that can be so far from what you want. As we look in society today, sometimes people are in a deep, committed relationship, but they are not married. And the law just doesn't recognize that relationship at all. And I have, not with my clients, but I sometimes hear about someone who dies without naming beneficiaries, without having a will or trust, and they wanted to leave it to, for instance, their girlfriend, but because they never married, She is not a part of the intestacy plan, and it ends up going to the guy's brother who he hasn't spoken to for 20 years. So it's going to revolve back to the, we need to do the planning. Planning's important.
Great. So during that planning phase, if you're going through a major life event, like a legal separation or divorce, should you wait for that to be official before you create the estate plan, or should you create something in anticipation?
That's a hard question. That's a really hard question, because you're right. When you're in the middle of a dissolution of marriage, your legal rights and your obligations are changing. My advice would be to consult with an attorney for sure, to get the specifics of your circumstance, and to see just what your options are. Some may be in the midst of what's called a conversion divorce. You might have signed a separation agreement, which then frees you to do your estate planning as you see fit. Others may be in the middle of a contested divorce, and you have obligations of essentially 1/3 of your assets to go to your current spouse, even though you're in the midst of a litigation to dissolve the marriage. So talking with your lawyer is really the only answer for that one. But that's an excellent question.
Great. So I guess we're going back to Yelena. Was another question for you.
Sure. Welcome back, Yelena.
Hi, thank you. My question, when we were in Florida, we attended a couple of workshops with the company, somewhat similar to yours. Our assets are all in our both names.
Yes.
Old fashioned. Been
Yeah.
married 40 years and shared last name, and the titles for our homes are, bear our both names, and we are each other's beneficiaries and whatnot. So unless there is a case then when we fly somewhere and we both pass away, which happens, but the probably more common thing is one of us goes before the other one.
Yes.
Okay, not to rule out other, accidents and whatnot, but let's just say it will be more quote unquote traditional way to go. So, and we were told that since we both share the titles, the this, the that, all bank account, and everything else, that the trust thing can wait until one of us is only living, because we will inherit automatically. Whoever is left, whoever lives, will inherit whatever we own, the homes, the this, the that. So I don't know if I explained myself correctly.
No, you did. You did perfect. May I just have your husband's first name?
He unfortunately he had to go. He had to fly today, and his name is Alex. His name is Alex, but he was supposed to be present with me here, of course. But
Okay, that's
yeah,
fine. No, that's fine. So, what you are describing about you and Alice is very common. Okay. And here's where the problem is, and why I believe that advice is not good advice. And that is, unless you and your husband can promise to just simply die, and no fooling around, no lingering, no getting sick, right? That's really the problem, because you own real estate. We'll just do real estate. And I think you use the plural on houses, like more than one home.
two.
Okay? Two. So you own homes that are in your name and your husband's name.
Correct.
Now, the nature of that is that it requires both of you to sign. It's not like a bank account where one of you can sign. That real estate requires both of you to sign. And if he
Sign for
was,
what? I'm sorry to interrupt. Sign
Yeah.
for what?
so say you wanted to sell the real estate, mortgage the real estate, rent the real estate, do anything with the real estate, you both need to sign together. Okay,
Right.
it's different than a bank account where one of you could sell it, you know, get money out of it. It requires both of you to sign. Now, in that particular case, if he became ill, you would not be able to sell the home, mortgage the home without the court's approval. Because what you're describing to me is no other planning is in place other than joint ownership. And
Right.
of course, if he did need care, the cost of that care, they would be able to assess against the real estate, and you would lose potentially the value of that real estate. If your husband needed care for 3 years and the cost of that care was $200,000 a year, then they will come looking to get the estate recovery reimbursed that $600,000 from that real estate. Additionally, many people have significant wealth in their retirement account, in their IRA, 403B, 401k. Again, your husband has named you as beneficiary, meaning if he would just cooperate and quickly die, that account would come to you. But if he does not cooperate, nothing happens with that account. You cannot even get out his minimum distribution without a proper power of attorney in place. So we need to have more planning than just naming beneficiaries. Now, I'm never here to tell you that you have to do this or you have to do that. I feel like my job is to advise you, like someone else asked, tell me what the pros and cons are. And the cons of waiting really show up if one of you gets ill. That's the big con, is that the downside is you will regret waiting to do the planning. The other big downside of waiting to do the planning is I see how emotionally devastating it is when someone loses their spouse. I want you to really think about this. There's a lot of decisions to make about how you and your husband are going to leave your life's work to whoever that is, the children, what family, charities. And to have to make all of those decisions without him, to have to make all of those decisions relatively quickly in time related to his passing, you know, like, do you want to go see the lawyer a week after he dies, a month after he dies, 6 months? It's not a really ideal time to be dealing with these things soon after the death of your spouse. So I would say, no, this is not good advice to wait. I hope that resonates or makes sense with you.
It does, but I also want to know, like, whoever lives, that person will not have a problem to keep living in the same house, owning the same assets. We won't have to probate the court on whatever. Am I explaining?
Yeah, no, you're explaining right. If someone does not do the planning, then they can live in the house, and when their spouse dies, I'm going to change the facts here for a second, and I really mean this. Let's say that you're the one who died first.
Okay.
Then all the assets go to your husband, okay, without any probate. However, if we don't have any trust planning in place, I believe, you know, women are stronger than men. Men get lonely. I have seen many, the widower, do what? Get lonely and remarry. And when they remarry, we get a significant issue going on, which is now all the assets are his. And now how much of those assets is he leaving to his new wife? How much of these assets is he leaving to the children of his new wife? We get a whole ball game going on that most people don't want to have go on. Now that's the truth of the matter is that surviving men tend to, we talk about it frequently. There's no fool like an old fool. Okay. So we, delicately need to talk about that, but that's for real. I really don't think waiting is the choice.
Okay. I understand. But so what will be a good scenario for for our situation? Which trust? What kind of thing?
We can't answer that here for sure, Yolanda. What you need to do is, you can come and meet with me. You can meet with an attorney of your choosing.
Okay.
Whatever. I'm going to give you the phone number for my office so you have it and it's easy. It's 631-265-0599.
Wait, 631
265
Huh?
0599. And my office is in Smithtown, right off of Main Street, close to the Smithtown Railroad Station.
Thank you.
Sure. Thank you.
Thank
Anything else? I think it's time for us to start winding it down here.
Yeah, we'll be sure to include Mark's contact information when we send a follow-up to everyone who was here this evening, so that you have that. A couple of rapid fire questions, Mark, and then we'll wrap up. I think we have a hard stop at 7:30 due to technological issues with Zoom. So can you simply transfer a house via will?
Yes. Yeah. I mean, people have done that for years. Prior to 1997, we didn't even have living trust or trust legislation in New York. People did that for years, but I just want you to think about the value of homes. In the 80s, you could buy a home in Stony Brook for $30,000. That house is now $630,000. It's a different world.
Right. Sort of along those lines, when and at what levels is inheritance or estate tax due?
So these levels are changing. Currently there's a federal limit and a New York state limit. The federal limit is over $12 million. The New York state limit is over $6 million. The federal limit is scheduled in 2025 to sunset or come back down to the, little better than $6 million limit. The Biden administration has always had a proposal to reduce it to $3.5 million. So these are political questions that move around. Just doing it by memory, just to kind of show you, in 2008, 2009, the amount that passed tax-free was about 1 million, maybe 1.5 million. In 2010, when George Steinbrenner died, it was unlimited amount that passed federally estate tax-free. So that was really helpful for George's family. It then returned back to, like in 2011, I believe a 1 million, and then worked its way to 5 million. So this is a political question. It moves around. We want to be cautious about estates greater than, I'd say, 3.5 million, that we think through what is the possible taxes.
Great. There's a lot of questions specific to each person's situation, so unfortunately we don't have time for those. I think the last good question we have is, if I'm not local to Stony Brook or Smithtown, how is it that I could find an attorney to work with?
So the first thing is, if you are in New York State, the pandemic taught us how to do business with people in upstate New York and places like that. So if you're not in New York State, then we would refer you to another lawyer I'm a member of the American Academy of Estate Planning Attorneys, a national organization of estate planning attorneys. And we field those phone calls regularly. You can go to their website. You can just Google American Academy of Estate Planning Attorneys, but you can call my office. And if you say you're in Georgia, you'll tell us what city. If you're, close to Atlanta, we'll send you to a lawyer that I've known for years, that kind of thing.
If we can get in one last live question, Charlie is the last hand raised. So if you'd like to hear his question, Charlie.
Sure.
Sure. Yeah. Well, actually, I think you just
Okay, great.
answered it, because I was saying, a lot of the good things you've been presenting here. I live in Houston, Texas, so I guess I need to probably contact you, and I'll get a local lawyer to answer these questions, because some of what you're saying might not be specific to here in Texas.
Yes, that's correct. There will be changes state to state. The lawyer I'm going to refer you to is Steve Mendel, the Mendel Law Firm. And you call my office, we'll give you all the details. But I want you to see that, like, we deal with folks all over the country. And when you say Houston, I know that's Steve Mendel.
Good.
Thank you. A great guy. Actually just saw him at a conference a couple days ago.
Okay.
So, very good.
Great. Well, I think that's all the hands that we had raised. There's still a few specific questions, but we're really at time. So, Mark, we cannot thank you enough for all your time. For everyone watching this, we'll send out Mark Aguirre's contact information, his phone number, and
As well as a recording of this entire presentation.
Thank you, Carissa.
Perfect.
Appreciate it.
Thanks so much for the questions. You guys made it so much more interesting than me just talking. So I appreciate that very much. And thanks for the opportunity to both of you for giving me the chance to talk to everyone. I enjoy it immensely.
Great. Well, thank you. Everyone have a
Great, thank
wonderful
you.
evening, and we'll look forward to hearing from you.
Thanks. Bye-bye.
Thanks, everyone.